So the officer is testifying as a witness, but he
No, I understand, but he was not a witness to the actual incident itself, correct?
That's correct. He was called in report and called.
Okay, I understand. I'm denying that. I'm going to allow you to put your witnesses, both of you, in any way that in fact you want to go ahead and can decide. Now, motion to prohibit any evidence pertaining to the defendant's arrest.
Okay, I guess I need clarification on that. First off, any evidence relating to the defendant's arrest could mean anything that the officer saw or did in the field. Also, there was no arrest in this case. The case was processed as a summons request.
Okay, so this was a summons?
Yeah.
Yes. So I have no objection to that one.
Okay. Well, and a lot of these, we're just going to have to wait, see what happens, and then you can object at the time. Okay, motion to prohibit any evidence or testimony witness believed a crime occurred or that the defendant committed the crime. Positions?
Your Honor, this is number 4.
Yes.
Okay. I guess the problem with that is lay opinions, even if they are on the ultimate issue, are admissible if they are rationally based perceptions and helpful to the jury. Expert opinions are admissible if they're relevant and the witness qualifies as an expert. And I think the line between facts and opinion is kind of thin. I can't get into opposing counsel's mind to think what he knows is a fact and what he knows is opinion. I think we're just going to have the court make its ruling as we progress along.
Okay. Mr. Wellman?
I think, stating the case law that is already stated in the motion, the prosecution should not elicit opinion testimony of whether or not the witness believes Mr. Gleason is guilty. So he should not ask the officer, do you believe he's guilty? Do you think he committed a crime? Or any other witnesses.
Well, no one should go to the ultimate fact. In fact, that's a question for the jury. However, if in fact we go there, he cannot determine. He can talk to the officer and the witnesses about not going there. But on the other hand, we may just have to determine that at the time of their testimony, because I cannot tell you right now if they're going to say that, if they're not. What I can tell you is that Mr. Schuman can talk to them about going to the ultimate.
Okay, defense is objecting to any witness opining the defendant's guilt.
And again, we'll determine that at the time. Motion to prohibit any evidence regarding defendants' exercise of their constitutional rights. That is, I agree with that. Obviously, they cannot say they didn't say anything. It cannot be used against them. So I agree with that. Mr. Schuman?
This is
Number 5.
Okay, I don't have a problem with that. He wasn't arrested, and he actually talked with the officer. So I guess the next question, motion number 6, we will be dealing with that. So the fact that his pre-arrest silence it's a question that kind of is irrelevant because he did talk with the officer.
Okay. Number 6.
Okay, the city does plan to have the officer testify to interviewing Mr. Gleason near the scene of the incident. It's not hearsay because it's not the defendant's own statement. Miranda, I believe, does not apply because it wasn't a custodial arrest. He simply went to the house, which was 2 blocks away from the incident, and interviewed him. I believe Volume 12, Washington Practice, Section 3110, testimony at the scene of the incident is not custodial, where the officers are going out to the scene and ascertaining the facts unless they place them under arrest.
Mr. Waldman?
My rebuttal would be it wasn't the scene of the incident. It was at Mr. Gleason's home. It was more than a block away. And 2, Mr. Gleason was not free to leave. He was not free to go about and do his business and go inside his own home and close the door on the police officers. In fact, they threatened him with arrest and towing of his vehicle and his brother's vehicle because he did not want to comply with them. So we would object to those statements as he was not able to leave. He was being detained.
So you're saying that anything that he said in his statements are not going to be allowed?
That's, yes.
Okay. We're going to deal with that at the time. Motion to prohibit any evidence, testimony concerning prior traffic citations or criminal convictions. I am going to allow them if they have to do with veracity. If they do not have anything to do with veracity, there's no reason to bring in traffic citations or prior crimes. Would you agree, Mr. Schuman?
Yes, I do, and I have no intention of bringing any prior incidents.
Okay. Number 8, prohibit allegations of prior bad acts. Mr. Schuman?
I was not anticipating bringing in.
So that is not something you're anticipating? Okay. Number 9, motion to prohibit evidence that law enforcement officers have special training.
I don't plan on, my understanding is that what Mr. Walden is driving at is that there is kind of what's called, that some officers use, a read technique regarding testimony, regarding veracity, where they can interview a witness and based on their observations, decide whether they're being truthful or not truthful. I think it's used in felony work. Our officers aren't trained in that, so at least our regular officers aren't. So I'm not planning to use it.
Well, that is extremely vague. What does special training mean? That he is going to be able to go into their training. What is special training?
So this means, Your Honor, in trying to use the officer as an expert witness, so going from a lay witness, which an officer typically testifies as, whereas trying to insert that the officer has some specialized training that makes them an expert. We are saying, no, they should not be able to introduce evidence that establishes the officer as an expert witness, only that he is a lay witness.
Okay, what he can go into, though, is his training.
Right, but he can't establish that he is an expert. There's a difference between a lay witness.
I understand the difference.
I'm just.
Okay, number 10, motion to prohibit evidence or testimony of awards, commendations, or accolades. What does that mean?
That those are superfluous to the officer's credibility, and that whatever awards and recommendations that he has previously earned are irrelevant and do not need to be gone into.
Okay, well, the bottom line on a lot of these, quite frankly, is that if you read the jury instructions, or jurors are the ultimate decision makers of credibility, so they are going to be allowed some leeway. We're not going to tie their hands and take out every possible situation where credibility can be questioned, because that is their role. So what is your position on number 10, Mr. Schuman? Is there anything you intend to go into?
No.
Okay.
I don't even know if he has it, so.
Okay. Number 11, motion to prohibit complaining witness as a victim. I have never heard Mr. Schuman call a complaining witness a victim. But again, Mr. Schuman, what's your position on that?
Just like you said, Your Honor, I never refer to the complaining witness as a victim. I usually refer to them simply by their name.
And that's absolutely fine. That's exactly what defense counsel is seeking.
Number 12, motion to prohibit evidence as a testimony of law enforcement as to what the law is. I'm going to allow that. That's not their role. That's a juror's role. Motion to prohibit hearsay statements. That is always a given. There is not going to be any hearsay. But is there anything you want to say about that, Mr. Schuman?
Your Honor, if we could go back to number 12.
Yes.
I guess I would oppose this motion. I have the case in front of me. I have the file right in front of me that counsel cited on that. There's no rule about witnesses giving legal opinions. Case was about the court failing to give a proper instruction. Having said that, I can tell the court and counsel that I don't plan on having anyone give legal opinions on direct, but I can foresee during the course of heated exchanges between cross-examination of the officer that, the officer could blurt it out. That's the concern I have.
Well, and this sounds like something that you can talk to the officer about. before he gets up there. The bottom line is there's not going to be heated exchanges. We're going to be professional today. And we're going to try to keep, if we can, objections to the minimum, because I'm going to be very frank. Jurors do not like a lot of objections, and it could blow back on your client. So the bottom line is, if you want to talk to the officer about that, I cannot see an officer actually telling the jury what the law is. And that's what that says to me. Mr. Waldman?
Right, just so, you know, the court understands, Mr. Schuman understands, motions to eliminate are prophylactic. They're to raise these issues so that, you know, the prosecution understands what defense is, so that Your Honor understands what defense is. I understand that some of these will need to be addressed as they come across. This is just simply a measure of protection for the defense to preserve rights on appeal.
I understand. Motion to prohibit hearsay statements of persons not testifying. Mr. Schuman, do you want to address that?
We have the hearsay rule. If someone gives hearsay testimony, it's subject to objection.
Correct. And so that would be open to objection. You cannot possibly cover every contingency. 14, motion to prohibit any evidence regarding characterizing, describing the initial report or 911 call pertaining to the alleged crime. Mr. Schuman?
Your Honor, the court has the PC statement. Essentially, and the city is planning to have the officer testify on what is said in the very first sentence of the statement. I responded to the 300 block of 21st Avenue for a reported fight in the street. I would argue that's not hearsay. Two reasons. One, the officer's testifying to what he did. Two, the report of the fight is not being offered to prove the truth of the matter asserted. I'm offering to prove why the officer was at the scene, even if the person calling 911 was lying through their teeth about the fight. The statement is still relevant as to establish why the officer happened to be there at the scene of the alleged crime, that he didn't just fall out of the sky or had some grudge against either of the parties.
Mr. Waldman?
I would, obviously the officer can testify to why he was going there, and he can use the PC report as his own written report to refresh his memory. We would just object to him testifying to what was in the report as he didn't, as to what the 911 call said itself, and or what was relayed that may have been written in the PC report or his statement by others. He can obviously testify to his own experience, but what we're trying to prevent here is him saying the 911 call operator told me this, or the
Sure.
person on the phone said this.
Is there actually going to be a 911 tape that's going to be heard today?
No,
Okay.
not that I'm not admitting it.
No.
Okay. And what's your response, Mr. Schuman?
Which number are we on now?
We're still on the same one. Number 14.
Okay, I just, essentially, I'm planning to have the officer testify to what I just, to the very
Okay.
first statement, and that's it as far as,
Okay, I'm going to go allow that. Number 15, motion to prohibit testimony which is based upon or grounded in hearsay evidence. Mr. Schuman?
okay, I guess I'm unclear as to what he wants.
It's very vague.
Yeah, I half of.
What does that mean, Mr. Waldman?
Law enforcement or other witnesses may not testify regarding their opinions and level of knowledge when such opinions or knowledge is based upon a hearsay statement from other witnesses, where the inescapable inference.
No, I know, we can read it.
That's what I mean, Your Honors, right there, what it says under State v. Johnson, that is the defense's example of what we're trying to prohibit.
Okay, I guess the concern I have is that could mean just about half of all knowledge. I mean, I know where I was born and what day, based on hearsay statements, somebody told me.
I think that's another one where I'm not going to rule on it right now. We're just going to see if it comes up. Number 16, motion to prohibit witnesses from testifying directly from reports. So are you saying, it sounds like earlier you said the officer could refresh his memory. Are you saying now he cannot or he still can?
No, I'm saying that he may refresh his memory, as is normal course, I think, within trials, but he may not read directly off of his report. He may not line by line to simply read off what he wrote.
Mr. Schuman?
Your Honor, the officer's not gonna read his report. He does have it with him. He doesn't need independent recollection to refresh his memory. I mean, if he had independent recollection, he wouldn't need to refresh his memory. I think the big problem I have with this order is that most of the time the contents of the officer's report gets out. When it does, it's usually through defense counsel who asks the officers about what's in their report. If the court grants this specific motion, how would the officer respond?
Well, the bottom line is that I am going to, again, I will listen to objections at the time, but Mr. Schuman's absolutely right, Mr. Waldman. You're gonna have to be very careful. If you open the door, then you cannot object that, in fact, you open the door and he refers to his report and reads directly.
Again, Your Honor, if defense counsel asks a question in which the officer doesn't know the direct answer, defense counsel will provide him his report to refresh his memory, and then ask for the report back before finishing and asking the question and having him use his memory to then answer. I'm simply attempting to prevent him from reading directly from his report or his PC statement.
Okay, I am not going to prohibit that at this time. We're going to see what happens. If in fact he starts reading it, I do not believe he will. And again, he should just be refreshing his memory. Motion to limit CAD. Are we expecting the CAD report?
Defense is not going to provide it.
No, we were not planning to introduce the CAD sheet.
Okay. Motion to prohibit any evidence witnesses are not testifying voluntarily.
I don't know if that is applicable in this context.
Well, and I'm not going to allow it anyway, because I'm always going to leave the door open if you need to establish someone as a hostile witness. I don't think that that's going to happen in this case, but we will see what happens, but I'm not going to prohibit that. Number 19, motion to admonish witnesses not to testify to the ultimate issue. Mr. Schuman?
Your Honor, I would oppose this motion. It's in 4 parts. The evidentiary rules are clear. The relevant facts and opinions are admissible even if they relate to the ultimate issue. I guess the real problem I have with this motion is that witnesses are not lawyers. Nearly all of them are probably...
I'm sorry, witnesses are not what?
Witnesses are not lawyers.
Okay.
Nearly all of them, my guess is that are not even college educated, at least the city's witnesses. Terms like speculative or conclusory fashion or going to the ultimate issue or invading the province of the jury are legalese terms. Additionally, as counsel mentions, the list is not exhaustive. What does one mean by improperly suggesting a crime has been committed?
This is an absolute objection, number 19. This is an objection. If someone is being speculative, you object. Objection, speculation. If someone is referring to the ultimate issue, you object. So this is absolutely an objection.
I think what defense counsel is just asking for is that the prosecution admonish their witnesses not to do that, so that they have a, prior to getting on the stand, they have an idea not to do this. That's all.
I am not going to ask him to tell them not to speculate, because they're going to have their own testimony and you're going to be tying their hands and they're going to be so confused about what they can say, what they can't say. That's going to be true with your witnesses as well. So at this point, I am not going to have them admonished as to, now certainly they should not talk to the ultimate issue. I really believe he's guilty, but on the other hand, I'm not going to rule that they cannot be speculative because, as Mr. Schuman said, they don't have the legalese. They're not going to understand that. They're not even going to know how to testify. You would give them a laundry list of what they can and cannot say. So we're going to deal with that at the time. B, the defense moves to prevent state from asking whether police officers are determined that a crime occurred. What does that mean?
One moment, Your Honor. I thought you were denying all of 19.
We're going to go one at a time. A, I'm denying. We're talking about B.
Oh, we're just asking the prosecution not to ask the officer if they determine a crime occurred. That's...
Mr. Schuman, you want to respond to that?
Okay. I guess what I was planning to do was at the testimony, at the close of the officer's testimony, what he did, he processed it as a summons request. That's all I was planning to do.
So just asking him,
I mean, what did he do? He just spoke with him, and then he didn't place him under arrest, but he sent it through as a summons request. That's what I was planning to have the officer do.
okay, Mr. Waldman?
I don't have an objection to that.
Okay. Defense moves to admonish witnesses not use the following terms: suspect, perpetrator, and again, it says this list is not exhaustive. Again, if you keep giving them words they can use, words they cannot use, then you are going to be tying everybody's hands. It's going to have a chilling effect. So I'm not going to have the defense telling witnesses, nor am I going to have the prosecutor telling witnesses what words they can use and not use. D, defendant moves the court to require prosecutor to instruct his witnesses. Okay, that's just an umbrella. Okay, 20, motion to prohibit argument by plaintiff. Jury must decide what happened or must determine which witnesses are credible. Mr. Schuman?
Okay. I guess I would,
I believe that
Your Honor,
go ahead.
I guess I would have opposed the motion as it's written in boldface. The court cited does say that it is improper that to acquit, they have to find that a witness is lying. I agree with that. There is a case law that says that. But what counsel is wanting to prohibit argument over is precisely what the jury is going to have to do in this case, and that is determine the credibility of the witnesses. That's what this case is all about, and WPIC 1.02 says as much.
Mr. Waldman?
We're simply objecting to the prosecutor telling the jury they must decide, they must determine the witnesses are credible. They can't say that it's up to the jury to decide what happened. It's up to the jury to decide if the witnesses are credible. That's normal course of language. We're objecting to the prosecution adding that extra weight and saying that they must. They don't. They can decide they don't know.
So if he makes that argument, then you have a counter argument that that's not their decision to make, correct?
I'm stating case law, State v. Fleming. I'm trying to prevent something that is considered prosecutorial misconduct and creating a situation for a mistrial. That's all, Your Honor.
Okay. I am not going to prohibit him from doing that. I don't believe he's going to do that. I'm going to remind everyone that the court is the ultimate, and the jury instructions tell them you alone, the jury, are the ultimate decision makers of the credibility. Motion prohibiting the plaintiff from personalizing statements and argument before the jury. Okay, what does that mean?
That means the prosecutor saying, I believe this happened. State v. Hale, that's prosecutorial misconduct.
Mr. Schuman?
Okay, I have the Hale case in front of me. It says during the course of the argument, the deputy prosecutor 3 times referred to the defendants and his witnesses as liars and twice indicated that he personally believed that. No, I don't plan on arguing that.
I have never heard Mr. Schuman argue what he personally believes in a trial. So I am not going to, and if he did do that, then you can object at the time. I'm not going to prohibit that because I don't believe he's going to do that.
So I just want to bring up, Your Honor, if Mr. Schuman does that, even post my objection, that now becomes a mistrialable conduct. So I'm bringing it up, just like in 20, so that we prevent that from happening, so that it doesn't happen, and that there is no risk of a mistrial. That's all I know.
Number 22, filing supplemental motions and supporting briefs. Is that an issue?
No, Your Honor.
And do you have any reason to believe that the state, or the city rather, has not provided discovery of evidence?
Oh, actually, I misspoke, Your Honor. I believe that there is evidence. I don't believe that the prosecution has that evidence. If they do and we're not aware of it, well, we would ask that that evidence be suppressed. As far as that's, as far as the defense counsel, that's, we're kind of across that bridge as we get there.
Do you believe that they have evidence they haven't produced?
At this point in time, I believe that they have produced all the evidence they have available to them.
Okay, Mr. Schuman, is there anything that the city has that they have not produced?
No.
Okay. Okay, is there anything else?
With the jury instructions, we would ask that the defense counsel's WIPIC for 17.02 be used versus the plaintiff.
Okay, well, first of all, I got your jury instructions. You did not do a cover sheet. You need to do a cover sheet when you do jury instructions. And secondly, are you going to have them prepared rather than just have the blanks in them? And is there going to be,
Your Honor, I have a pair of marked instructions and unmarked. I haven't given them to the court yet, but I have them, and Mr. Waldman has a copy of them.
okay, and do they also have the instruction as far as self-defense then?
I put in all of the instructions I thought were applicable to self-defense. I think Mr. Waldman's reviewed them.
Okay,
Well, the reason why I would just prefer for our specific WIPIC 1702 for that the defense submitted, even though it's broad, is that it does allow more language. I think it allows the jury to make their own decision about what applies versus the narrow instruction provided by the prosecution. Other than that, the 1704, I believe, is the other one. That's perfectly fine that the prosecution provided, and the other jury instructions, defense has no objection at this point.
Mr. Schuman, is 1705 included in yours?
I believe it is that's the duty to.
Duty to retrieve?
Yes, I did provide.
Okay.
that. In fact, I can just provide.
Okay.
1702, 1705.
Okay. Now, has everyone gone over the jury book? Then we don't have a select list yet, right?
We just got it.
We just got our okay.
Your Honor, there was also my motion to amend to, it should be in the court file.
Yes, there was a motion to.
We just need to deal with that.
Thank you. Okay. Okay, we ready to start?
Yes, sir.
Okay.
Can we make sure that the witnesses are here?
Are your witnesses here?
My
Are your
witnesses-
witnesses?
My witnesses are here, Your Honor.
Okay.
My witnesses have been subpoenaed for 9:30.
Okay. Now, you do understand that there is another pool out there just in case, because we have had the situation where we've run out of jurors.
Yes, Your Honor.
Okay, so we have this, are we gonna give it some time to just make sure that we check through our struck list to see if there's somebody we don't know or we know or somebody?
Have you not? Oh, yes, you probably need to look that. Well, have you looked at the jury list already
No.
Just
of who the
received it.
jurors are? But, I mean, you know who the potential jurors are? Even before the struck list?
I don't have anything on the
Okay.
list.
No, Your Honor. All I have is this that was just provided before we sat down.
Okay.
I guess I don't have that yet.
I have it for you guys. I can give it to you. If you want to take a quick recess, let them look that over. I also have some technical issues that need